welcome. My name, for you, those of you that don't know me, I'm John Giordano. I'm a partner here at Citrin Cooperman, where I co-lead our firm's manufacturing and distribution practice. At Citrin, our goal always is to bring value-added solutions to our clients and the business community through not only our core competencies, such as financial statement work and tax, but also through general business consulting, various advisory practices, as well as our industry expertise. Aligning ourselves in the market as a premier middle market firm, we are able to provide solutions to business owners with not only through our industry professionals, but also other professionals who work alongside us in the marketplace that may bring aspects of subject matter expertise, and we're able to bring that value to you. Today's webinar, appropriately titled Navigating Tariff, Trade, and Customs Compliance in Today's Environment, is meant to help those directly or indirectly affected by the current tariff landscape stay up to date on the current state of affairs, potential mitigating factors, and an update on the current enforcement environment surrounding it. So navigating here, our speakers today will be myself as moderator, Tom Cook, the president and CEO of Blue Tiger International, and from Citrin Cooperman, we're going to have Kevin Tanaka and Atul Chandra. Again, briefly to just touch on our agenda for today, we're going to have an update on the tariff landscape, some trade and customs compliance update, at which point we'll transition to a brief roundtable discussion. We'll ask 20 questions to our presenters, and then we'll open it up for some general Q&A. So at this point, I'd like to introduce Atul Chandra and Kevin Tanaka. Atul and Kevin are partners in Citrin Cooperman's forensic service practice. They're co-leaders of our financial investigations and regulatory enforcement team. Together, they work to assist our clients and their legal counsel with internal investigations and defense and regulatory investigations and legal proceedings. With decades of hands-on experience with whistleblower investigations, DOJ actions, False Claims Act proceedings, among other high-stake matters, when they're not helping clients in reactive situations, they're proactively helping our clients prevent violations and by strengthening our compliance programs. So without further ado, I want to turn it over to Atul and Kevin. Thanks, guys.
Thank you, John, and good morning, everybody. Thank you for joining us today. Like John mentioned, what we wanted to do was to kick off with some of the updates from the Department of Justice, enforcement priorities, cross-agency trade task force, the whistleblower programs that are out there, a brief touch on the False Claims Act, along with case studies and the current compliance environment. Kevin, do you want to say anything before we kick off?
Yeah, no, we're kicking this off. I mean, I think this audience is pretty familiar with, the Customs and Border Protection and their involvement. But we want to kick it off with, just a little bit of background on the Department of Justice and their involvement. This past May, they've pretty pronouncedly come onto the scene with, different policies, their whistleblower program. So we've kind of divided this up into two segments. So Atul will walk us through, the policies that they've come out with, but we'll pivot the back end of the conversation more towards, the compliance programs and, frankly, how you can avoid getting into trouble with the DOJ. So with that, maybe we can kick it off, Atul, and jump into the DOJ.
Sure, absolutely. In discussing today's regulatory enforcement environment, we must begin with the Department of Justice. The DOJ has expanded its role in tariff enforcement and treating tariff evasion as a major risk. It does not mean that the prior regulators, the Customs and Border Protection, CBP, is going away. If anything, the DOJ is going to augment, not replace the CBP. As part of numerous engagements that Kevin and I have done for our clients, we have frequently interacted with the regulators, including SEC, FINRA, state attorney general's offices, other regulators. And it's not uncommon for us to see the DOJ get involved, but when they do, the stakes are just so much higher. DOJ's mere presence in this area, in tariff and trade compliance, is newsworthy in and of itself. Their role is expanding rapidly. They have a number of different tools and resources that they have in their toolkit to enforce trade and tariff compliance. Earlier this year, they've announced a new trade fraud task force, which is a cross-agency coordination between the Department of Justice and the Department of Homeland Security. They've increased monetary awards for whistleblowers, civil remedies under the False Claims Act, and criminal referrals where appropriate. And we'll touch on each of these in subsequent slides. Moving quickly, back in May of this year, the head of Department of Justice's Criminal Division put out a memo to all Criminal Division personnel titled Focus, Fairness, and Efficiency in the Fight Against White-Collar Crime. In the memo, he had explicitly said they want to focus on trade and compliance fraud, including tariff evasions. He wants a fairness in prosecuting corporations and individuals. And the Department of Justice wants to be extremely efficient in ensuring bad actors are brought to justice swiftly and effectively. In the memo, he had mentioned trade and customs fraud, including tariff evasion, is a top priority and a high impact area for the Department of Justice. The memo also explicitly references key policy changes, including an introduction of a whistleblower program for the Department of Justice, amendment to the Criminal Division's corporate whistleblower program to add tariff, trade, and customs fraud by corporations and individuals as a designated subject area for the Department of Justice. As I mentioned earlier, there is a big cross-agency coordination happening between the Department of Justice and the Department of Homeland Security. Some quick facts. The Trade Fraud Task Force was launched in August of this year. It reiterates trade and customs fraud as a top priority for both agencies. It is a joint venture partnership between the Department of Justice and the Homeland Security. Let's take a closer look in some of the key agencies underneath each of the agencies and the roles that they're going to play. Under the Department of Justice, the Criminal Division, as its name implies, becomes involved when violations rise to a criminal level. The Criminal Division sets forth key policies, including an enforcement plan and the DOJ whistleblower program. The Civil Division, on the other side, litigates and investigates some of the Civil Division's largest and most significant cases. They work very closely with the state attorneys, investigative agencies, and whistleblowers, and have recovered more than $78 billion in False Claims Act settlement since the False Claims Act went live in 1986. We expect the commercial litigation branch will play a critical and a central role in a number of these trade-related matters. Moving on to the Department of Homeland Security, the CBP, or the Customs and Border Protection, will continue to play a central role in coordination with the Office of Field Operations in identifying, investigating, and enforcing these trade violations. Within ICE, Homeland Security Investigations, or HSI, resources are enlisted to help identify and combat trade violations. Their priorities might be in other places right now, but their personnel can and will be used for some of these investigations for trade violations. The announcement of the Trade Fraud Task Force comes with some important takeaways. Violations and remedies. The announcement further specifies the type of violative acts under the scrutiny and remedies of the government. This includes anti-dumping, countervailing duties, and Section 301 duties, penalty collections under the Tariff Act of 1930, actions under the False Claims Act, seizures under Title 18's trade fraud and conspiracy provisions, and parallel criminal prosecutions where appropriate. The task force also has enhanced and extended the whistleblower programs. As I mentioned earlier, the Department of Justice is using the False Claims Act as a tool to go after bad actors. And the announcement explicitly encourages all importers and their agents to conduct thorough audits of their importing practices and voluntary self-disclosure and remediate unlawful behavior. So there is a big incentive for doing internal audit and self-disclosure where potential issues are identified. I want to touch briefly on the numerous whistleblower programs that are out there because there have been some expansions to that. The Enforce and Protect Act is administered by the CBP, and it establishes procedures for an interested party to submit allegations involving anti-dumping and countervailing duties. An interested party in this case, though, is a person or company with direct interest in trade disputes. Example, a foreign manufacturer, a US importer, a domestic producer, or a trade association. Unlike all the other whistleblower programs that I'm going to touch on, the Enforce and Protect Act does not provide for anonymity. In other words, the whistleblower or the interested party has to provide their true identity and contact information. Since its inception in 2016, the CBP has reported more than 450 investigations and identified over $2 billion in anti-dumping countervailing duties owed to the US government. A substantial majority which involved illegal transshipment. The e-allegations are by the CBP, but it's open to the general public. You don't need to be an interested person. And it goes beyond anti-dumping countervailing duties. Common reported trade violations include misclassification, undervaluation, false country of origin, broker violations, trade agreements, illegal transshipment, and of course, anti-dumping and countervailing duties as well. The e-allegations allows for the whistleblower to be anonymous and is another tool that the CBP uses. The DOJ's whistleblower program was launched in August and it was revised. It was launched in August of 2024 and revised in May of 2025 when the memo came out. The memo, as I mentioned earlier, specifically includes trade, tariff, and customs fraud as a designated subject matter area for which whistleblowers are eligible for an award. The False Claims Act, finally, is the oldest toolkit in the Department of Justice's tool. It was established in 1863 and the government's primary litigation tool in combating fraud against the federal government. Expanding a little bit more into the False Claims Act because this is new in the trade and tariff compliance space. The False Claims Act, again, a law that was set in 1863, and it's now being used by the Department of Justice to combat trade, tariffs, and customs fraud. The False Claims Act can be used to penalize any individual or company that knowingly submits or causes another to submit fake or false records to the government. There are two types of False Claims Act. False claims submitted to the government for payment, or false claims submitted to avoid or decrease an obligation owed to the government. In other words, a reverse false claim, an exact opposite of what a false claim is. Both of these are litigation tools under the False Claims Act. Prohibitive acts include using a false record in furtherance of making a false claim or a reverse false claim, conspiring to commit any or all of these acts. As a result, penalties on a False Claims Act basis can multiply very quickly. The whistleblower process at a very high level involves a whistleblower, or in the case of False Claims Act, they're called a relator. A relator can file a complaint under seal with the federal government, which remains confidential while the government investigates. The government can decide to either intervene and prosecute the case or not take action. If the government intervenes, it takes over the litigation and the investigation everything that comes with it. And the relator receives a percentage, typically 15 to 25% of whatever is claimed back by the government. If the government decides not to intervene, the relator can choose to proceed with the lawsuit alone and may receive a larger percentage, up to 30% if successful. We wanted to set the stage with what is going on from a regulatory standpoint and all the tools that the government has. I now want to turn it over to Kevin to speak through a case study of a recent False Claims Act matter, as well as compliance programs that can be put in place. Kevin?
Thanks, Atul. Really great overview. Just one point of clarification for the audience. I heard you, Atul, mention two different dates. So the False Claims Act originated, I think it was 1863. It's whichever year it is, super old. But you mentioned 1986. So just the clarification there, that's when they started tracking, the awards and the settlements under it. So either way, powerful enforcement tool for them. So I wanted to walk you through three recent settlements, and these are, again, just to put the context around it, these are the key TAM settlements, specifically under the False Claims Act. These are recent in the sense that they were recently announced by the DOJ, and we'll walk through, there's three specific cases, Evolution's Flooring, the second one, Grossfilex, and Allied Stone. This audience, you've probably read through them. So we're not going to go through them individually one by one, but just wanted to touch upon some key themes that we saw through all of them. The first point, just it covered, a wide range of different violations. As Atul had mentioned, some of the common themes are misclassification, anti-dumping violations, country of origin. So these were all present across these cases. But as we dug deeper into, the specific allegations, and again, these were just, the settlements were resolved, allegations only. But, some of the allegations that were included in there as you dug through, and we can consider these kind of aggravating factors that the DOJ will factor in when they're making, charging decisions and their sentencing. In one particular instance, there was a failure to correct a prior false customs forms after, this particular importer became aware of it. So certainly that was an aggravating factor that they considered. The other interesting point that we had noted was in one of the cases, the DOJ was not just looking at the behavior of the importer themselves, but also extending, the potential liability to, third parties. So including, manufacturers and third-party entities that served as the importer of record. So kind of the key takeaway there is looking at not just the activities within the importer themselves, but their nexus to the third parties and their responsibilities for supervising and understanding, the record keeping there. The other point that we wanted to take a look at and discuss with the audience here is, frankly, I'll refer to these as old cases, right? So even though these were recently announced, when you take a look at the relevant time period, right, and that's the time period when the underlying entries and the importers were actually bringing the merchandise into the U.S. So when you look at the underlying cases, some of them date back to 2014. And, the key takeaways there is that, you could have had, activity that's not just, during the current Trump administration or, under the recently imposed tariffs. There's a far look back period that these cases can go into. So first point is the relevant time periods. The second time period that we look at is the point in time when the whistleblowers actually came forward with their allegations. And across these, these were back in 2000, 2001. So an important key takeaway there is the time that it will take to conduct the investigation themselves, right? So, if these allegations were initially raised 3 or 4 years ago, the time that it actually took to get the settlement is, in these cases, 4 or 5 years. So, despite the government's, best foot forward to be as efficient as possible, sometimes with the cost that's involved, the record keeping, gathering together the information necessary to come to the settlement, it can be extremely, time consuming. The other point that we wanted to mention here is that when you take a look at the individual cases and consistent with what the DOJ has said of going after individuals and not just corporations, in 2 of these cases, senior executives of the companies were actually named specifically in the settlement documents. And notably in those cases, they have actually had to come out of pocket to, fund part of the settlement. And in one particular case, part of the settlement funds were actually going to back pay for the legal expenses that were incurred by the whistleblower themselves. The last point here is, the settlement amounts can be significant, and we'll touch upon a little bit later about how the government actually comes up with these calculations. But key takeaway here is that these are not small fines and penalties. When you take just these three cases, and add up the total settlements, you've got over 25 million. Individual cases are ranging from 4 to 12 million across these cases. And last but certainly not least, and what sets the stage for kind of the current environment is going to be, prominent rise of whistleblowers coming forward. In these particular cases, under the False Claims Act, there's a significant award that can go back to the whistleblowers. So in these cases, added up altogether, there was about 4.3 million that was awarded to the whistleblowers themselves. So now we'll pivot to compliance programs and frankly how you can try and stay away from these issues. So we'll have links at the end of this presentation to some of these key documents, but really wanted to focus some attention on the Department of Justice, their evaluation of corporate compliance programs. Different government agencies, put out various different frameworks of what constitutes an effective compliance program. But, given the DOJ's prominence in this space now, I think it's definitely a highly recommended reading for you. It's about 25 pages. And really this is an iterative document that, throughout Atul and I in our time working in this space, the document itself has evolved over time. It's iterative. They've built upon, lessons learned that they've had from various different cases. So the most recent one was last revised in September 2024. So if you go to the DOJ's website, that's the version, the most current version. So diving, into compliance programs themselves, frankly, this is probably the best defense that importers can have in terms of, strengthening their position and mitigating against potential enforcement risk. This is something that the DOJ has consistently gone towards and, frankly, deciding whether or not they're going to make charging decisions. So just touching upon a few of the components, and again, DOJ emphasizes that there is no one-size-fits-all program. They recognize that importers come in all shapes and sizes. Some are small, some might be sole proprietorships, going all the way up to massive organizations that have their own embedded internal compliance departments. So what they talk about is specific hallmarks of what they expect in compliance programs. And they don't take a check the box approach, expecting every company will have every single one of these either applicable or in place in their organization. But they talk about this in the context of what they expect to see or what can be mitigating factors, again, in their charging decisions. So just, to cover a few of them, they talk about tone at the top. This is basically the messaging from the senior leadership. If there's a clear, tone that's set, that there's, no tolerance for non-compliance. Program governance is really speaking to how is your compliance program structured, right? Do you have a dedicated chief compliance officer? Have you outsourced that? Again, their understanding is, not every company is going to look the same, but if the DOJ does come knocking on your door, they're going to want to understand what was the rationale behind why your current compliance structure is the way that it is. Risk assessment, this is the backbone that sets the stage for your entire compliance program. Again, no one size fits all. Some companies will undertake a basic questionnaire. Some companies may do this on a monthly basis, may do it on an annual basis. But the key is to actually have, a formalized risk assessment process, really so you can understand what are the unique factors that impact your particular business, taking into account factors such as your geographic location, the complexity of your supply chain, your international operations. Policies and procedures, this is, frankly, do you have written policies and procedures that build upon the risks that are identified in your specific risk assessment? In this particular case, at minimum, probably what they're expecting is that you do have explicit policies and procedures that govern some of the issues that are at play today, like classification of goods, your valuation procedures, your record keeping procedures, training and communication. This is going to be, again, custom tailored to the size of your organization, but making sure that, these policies and procedures are adequately disseminated across your organization and understood by the employees, who are operating there. Internal controls and monitoring, when we think of this, again, not one size fits all, but do you have an internal audit department? What are the third set of eyes that are actually testing and monitoring to make sure that your controls are in place and operating as intended? And then what I want to, briefly pause on here, and I think this is going to be an important critical factor, is confidential reporting and investigations. Atul had touched upon, the number of whistleblower channels, but it's important to understand that, companies need to have or should have their own internal reporting mechanism, right? If a whistleblower comes forward, and we'll touch upon this in a couple slides from now, but if a whistleblower were to come forward and report that to the government, but in parallel, they also had made a report internally to, the company or the importer, alleging potential violations, a company can still qualify for a declination if they, within 120 days, the company actually self-reports to the government, while a whistleblower may have in parallel reported to the government. So it's critical that companies think about having, an adequate internal whistleblower mechanism. Third-party due diligence, won't go into too much detail on here because it's again in the eye of the beholder, right? If you're an importer, third-party due diligence may be focusing on how do you manage your relationships with your customs brokers, with freight forwarders. I think another really important part here is the documentation and record keeping. One stat that, definitely stood out to me in just looking through the CBP's audit reports and thematic findings, this is one of the most common areas where they find deficiencies. Again, there's about a 5-year statute, or not statute of limitations, but a 5-year minimum record keeping requirement, both for importers and for customs brokers. And why this is so important is that, again, if the DOJ does come knocking on your door, not having, complete records, accurate records, missing records, again, this has clearly been a common theme for CBP audit findings, but that's also going to be important if the DOJ does come knocking on your door. Last but not least, if you look in, there's, the nuts and bolts and nitty gritty questions within the DOJ's, 25-page document, but ultimately they come back to 3 key questions. And specifically, these are questions that are given as guidance to prosecutors in asking, when they're, again, making charging decisions, whether or not to prosecute. Is your program well designed? Is your program adequately resourced? Does it have the proper funding? And does it work in practice? So again, they take a very pragmatic approach to their enforcement. Okay, pathways to resolution. Again, this is another, I would say this is probably the second most important document. I would start, if you do have some takeaway reading, look at first the, how the DOJ evaluates their compliance programs. But this is a separate document, and Atul touched upon this. This was recently revised in May of 2025. This is their corporate enforcement and voluntary self-disclosure policy. And again, this is not necessarily a new policy. This has been in place for many, many years, but what they have put in here is to make it crystal clear. If you do identify a problem, how can you, get to a resolution in favor? So they handily, color coded these. So obviously the ideal situation, if you do have a violation, is to get to the green, which is a declination of any criminal enforcement action. And what the DOJ effectively does here is they walk through step by step the key considerations that they have in determining or awarding a declination. The key takeaways there, it's voluntary self-reporting. Again, coming forward, with information, and that could be in parallel to a whistleblower. So key to remember, that 120-day rule is that if you do identify a violation internally and you self-identify it, probably best practice to assume that a whistleblower could have reported that to the government. So as soon as you identify it, you've got 120 days to self-report that to the government. Another key factor that they consider is full cooperation. In practice, when Atul and I have worked on this, lots of questions are raised of what constitutes cooperation. What does good cooperation look like? Some folks have argued that cooperation is just the expectation, not the basis for an additional award. So full cooperation, what we've seen is frankly, being very proactive with the government, not waiting until they come and ask you for questions. Voluntarily, one particular example that we'll walk through is, doing your own damage assessment and impact analysis. Again, the government is, very mindful not to, allocate too many of their own resources. So the more work, candidly, that you can do for them, that'll work towards cooperation. Remediation effectively has a few different legs on it. Remediation can involve, where it's appropriate, disciplining employees that may have been involved or senior executives that may have been involved. Remediation can also include any compliance gaps or any compliance failures that were noted during your investigation. What have you done to remediate those compliance gaps? And last but not least, and probably the most important, is remediating any shortfalls, in this case of taxes or duties that were owed. So to the extent, rather than waiting for the government to come up with their own calculations, if you do your own damage calculations and proactively stay a step ahead of that, that's going to help your case towards, getting awarded good cooperation credit. Last but not least, aggravating circumstances. Again, we kind of touched upon that in some of the case studies where if you knew about errors and you failed to correct them, if you were not forthcoming, if there's senior leadership involved, these are just examples of aggravating factors that may impact, your possibility of a declination. But behind declination, some of the yellow boxes and the red boxes, even if you don't qualify for the full declination, the government is clearly, indicating here there are still benefits that can be had. And most notably is reduced penalties. As Atul had mentioned too, with False Claims Act and with other violations, there can be treble damages, multipliers to not just the taxes that you owed, but the additional penalties on top of that. So by showing, good cooperation, that's probably the greatest incentive, is to, potentially reduce those penalties. Okay. How are we doing on time? I know, Tom, we're going to give you some time, so I'll quickly walk through this. Another good case study, and this is in the matter of global plastics and Marco Polo. Again, another case that was just announced recently in 2025. This is a good example where in the announcement and the settlement documents, the government gave them specific credit for cooperation, which ultimately reduced penalty that they otherwise would have levied. But the key takeaways there is that the government in this case specifically pointed towards steps that the company had taken, which constitute, good cooperation and remediating them. So obviously, they made a timely voluntary disclosure about the potential violations. They did their own independent and thorough investigation. A little bit self-serving for Atul and I. This is, frankly, our business and where we come in. Oftentimes we have found, companies doing their own internal investigation, which may be fine. But candidly, when you have, the potential for influence, by internal executives, that's, can immediately erode your credibility. So when we come in and we perform an internal investigation on behalf of the company, effectively, we can report back to the government and enhance that credibility factor. Another key point there is preserving and collecting, data that was associated. Again, going back to the CBP's common audit finding, where you have insufficient record keeping, where either the records are incomplete, they suddenly go missing. To the extent that you identify an issue, put a litigation hold, preservation notices out to keep those records intact. That's going to be key to maintaining your credibility. Last point, or second to last point, we had mentioned is doing a thorough, damage assessment. So again, rather than waiting for the CBP or the DOJ to come up with their own calculations, by doing your own calculations first, cutting out the noise, that's going to help in those efforts. And last but not least, we touched upon this, the remediation efforts. So, implementing new controls, disciplining personnel where it's appropriate. Those are also going to be key factors. Okay, and last but not least, we'll just briefly touch upon this. Atul and I have fielded a ton of questions on what's going to happen, with the Supreme Court ruling, and is all of a sudden the DOJ going to disappear on this? Our view on this, frankly, is that, tariff evasion was illegal. It's still going to be illegal before and after the Supreme Court ruling. The Supreme Court specifically, they're ruling on the legality of Trump's authority to impose certain tariffs, but not on the legality of evasion itself. That's not going to change. And when we take a look back at the case studies that we went through, noting that the activity that was involved, dates all the way back to 2014, combine that with the number of, record-setting whistleblowers that are coming forward, even if the Supreme Court does come forward and overturn these tariffs, in our view, it's not going to, halt enforcement of tariff evasion allegations. So just a quick touch point on what Atul and I do. We come in and we typically work with in-house counsel and external counsel. Could be in a variety of contexts. Most commonly, we help with internal investigations, again, coming with that independent lens. If need be, if the regulators do knock on the door, whether that's CBP or DOJ, we assist, with the regulatory response. If it does go into litigation, specifically in a False Claims Act, Atul and I have done a ton of litigation support work specifically involving the False Claims Act. And then last but not least, as John had mentioned at the top of the call, we do when we're not putting out fires, so to speak, we help companies, evaluate their compliance programs, taking a look at, doing a benchmark against some of the DOJ's expectations. Do you have tone at the top? Do you have your policies and procedures? Do you have a whistleblower hotline? We can help, do a gap assessment and, performance improvement plan. And last but not least, a lot of the calls and the questions that we're getting, not specific for our forensics practice, but within our, transaction advisory services. Obviously, what's going on, across the marketplace, with either, M&A activity, buy-side due diligence, sell-side due diligence, or frankly, if even lenders are coming in, if, importers are borrowing from banks and the like, there's questions around, tariff exposure. How do you quantify that? Are you operating in China or Thailand or Canada? And what are the impacts of those tariffs on your financials? And how does that impact, your enterprise value? How does that impact if you're putting your company up for sale? These are key questions that are being asked. So
I just want to say thank you guys again, Kevin and Atul. I know it's not necessarily what we want to be talking about in terms of these types of subject matter, but I think it's important for those that might be affected, are aware of the current enforcement landscape as well as the potential consequences for non-compliance. So again, I thank you guys for bringing us on an update on what that landscape looks like. I think a lot of the fear is that, as things continue to progress, it'll be looked at as another revenue stream for the government to go after companies that are not compliant, even though they might feel that they're compliant. So I think it's a tricky landscape. So I thank you guys again for putting that together for us.
That's a great point. And frankly, from what we see, and kind of the scary part here is that I would say, I won't put a number on it, but, the vast majority of companies that we encounter, that they are compliant, they're well-intentioned. I think the danger here is that even a small mistake, right, a small misclassification, an inadvertent mistake, that will draw regulatory attention, right? So whether that's a CBP audit, if that gleans the attention of a whistleblower, so what we commonly refer to as like a false red flag, right? That can still bring a company into a costly investigation, even if at the end of the investigation, there's no finding of wrongdoing. That's why it's good to stay one step ahead and understand how, the DOJ operates. So, put yourself in that best position, even if there is just a mistake or a false flag.
You spoke a lot about the DOJ. What are the DOJ's other specified priorities, besides trade, tariff, and customs fraud that maybe some of our listeners can be in tune to?
That's a great question, John. Broadly speaking, the DOJ prioritizes areas that have the greatest impact in American citizens and companies in protecting American interests. Stated priorities: terrorist financing, money laundering, sanctions, manufacturing and distribution of fentanyl and opioids, bribery, fraud that victimizes U.S. investors. So a wide gamut of extremely high priority risks. to U.S. and American citizens. The fact that trade and tariff compliance is now on their radar says something about it, of how important they're treating it. The DOJ has listed out a list of top 10 high risk areas, and for the first time, trade and customs fraud is in it. So it's definitely something that they're prioritizing and focusing on. Good question.
Regarding earning cooperation credit, I know something that you guys spoke about throughout your presentation. Can you elaborate on some of the examples and best practices, pitfalls to help maybe avoid in addressing those?
Kevin, you want to take that?
Sure. Yeah. Well, frankly, I'm going to toot our horn a little bit. Dealing with some other regulators, they come up with their own different terminology, but there's cooperation credit, full cooperation credit, extraordinary cooperation credit. So, Atul and I have had the privilege of working with some legal teams and formulating strategies where we actually have achieved that, extraordinary cooperation credit, which ultimately resulted in, zero fine and zero penalties for some of our clients. So, if you look at it day to day, really that blocking and tackling that really makes the difference. When we're working with legal teams, we're interacting, we're having discussions with the regulators, interfacing with them. Frankly, this is just the day to day. And candidly, kind of common sense is, be timely. Don't wait for the government to come to you. To the extent that you can be very proactive and come and share information with them, new information that they hadn't previously been aware of, that's certainly going to help your case. Providing facts and not arguments. Needless to say, DOJ, that they're human beings too, and if you're putting them in an adversarial position and really digging your heels into a certain case, it helps just to explain the facts. And so being organized, Atul and I spend a lot of the time actually, working with massive amounts of data, and by stripping out the noise, by putting it into chronologies, providing an index. It's not helpful if you just hand over to the government 40,000 pages of a PDF without an index. To the extent that you can make their life simpler, that's going to demonstrate cooperation. Putting the to that point also in usable formats. If anybody here has ever received a subpoena or a request for information, they're very particular. The government is about the format of the information, how they want to organize, how they want to present it. So again, going back to just making their lives easier, that's going to help things. And being, aligned with the government's resource, pressures. We obviously see with the government shutdown, the DOJ, with their civil division and criminal division, they've got tons of other priorities. So, to the extent that you can take, some of the workload off of them, that's going to, just help day to day. Some of the pitfalls to avoid, maybe it's kind of the converse of what we just described, but, certainly don't overpromise and underdeliver. A lot of, the RFIs or subpoenas may come with specific deadlines. And if you miss that deadline, or if you ask for an extension and don't meet that deadline, that's a surefire way to, erode and destroy your credibility. Slow walking through the investigation, that's not going to help. To the extent that there's record keeping lapses, again, this goes back to the compliance program, the importance of record keeping. If you have incomplete or missing documentation, that's certainly a pitfall to avoid. To that effect too, selective production of documents, or in just plain English, if you're cherry picking facts, that's not something that's going to the government's going to take kindly to. Usually they do discover those sorts of gaps, and when they do, they could interpret that as being intentional. The other point that we had touched upon briefly before is conducting an independent investigation. There have been instances where we've seen a company has performed an internal investigation that might have been subject to we'll call undue influence by executives to arrive at a certain conclusion. So certainly that's another pitfall to avoid. And then I would say, maybe the last key point is failing to follow through on remediation, right? As part of, these settlements, companies may have to agree to an undertaking, right? So if you've presented to the government to, finalize your settlement, you may have said, okay, we've identified, this list of 10 compliance gaps, need to improve our training, need to improve our, policies and procedures, revise our risk assessment. At the time of the settlement, some of those, may have already been completed. Some of them may be in flight. Some of them, you may be scheduling for next quarter or next year. If you have a deferred prosecution agreement where you've promised these undertakings but you don't follow through on them, that's certainly another pitfall to avoid, and frankly could lead to the implementation of an independent compliance monitor, which not a situation that you want to be in. So certainly lots of day-to-day pitfalls Atul and I have seen through our time of problems to avoid.
We do have Tom joining us now. Tom is the CEO and Managing Director of Blue Tiger International. With over 30 years of experience in assisting companies all over the world manage their import and export operations. He is a subject matter in all things supply chain and a member of the New York District Export Council, Director of National Institute of World Trade, and sits on the board of various different corporations. So, Tom, it's your show.
Great. I just want to add a couple of additional points relative to that subject matter regarding compliance. The first is that while this whole focus of the conversation relates to imports, everybody who's also involved in exports needs to understand that the government is acting just as aggressively on export controls as they are on import controls. There's a CBP enforcement team for exports, and then you have the Department of Commerce, the Bureau of Industry and Security, the Office of Asset Controls and Treasury, and ITAR in the State Department. So keep in mind that the government is aggressively going after export compliance controls as much as they are import. There are three basic principles to compliance that you need to have in your program. We work with Citrin Cooperman in doing those types of audits and also hopefully correcting the behavior to make sure you can conform to U.S. import and export regulations. But you have to act with due diligence, reasonable care, and with supervision and control. Due diligence and reasonable care relate to compliance with the regulations, knowing what they are and how they apply to your supply chain. And supervision and control means that a lot of companies outsource a lot of their supply chain responsibilities to custom house brokers and freight forwarders. And the government says to you that that's perfectly fine, but you have to supervise and control their activity, which means that while you certainly trust them and you have faith in the work that they do, you have to have systems in place to make sure that you're reviewing the work that they do and that in fact is correct. As a perfect example, harmonized tariff numbers, generally a lot of time that's left up to your broker and your forwarder to help you decide which one to use. You need to make sure that that number that they're referencing to you is actually correct. Just be aware of those things relative to this whole conversation. So in the slides deck here, I'm going to walk you through. Everybody's very well aware that there are always issues involved in international trade, from geopolitical issues to wars, weather, hazards, and just dealing with government agencies, both on the import and export side. But in recent times, particularly since Trump has taken presidency, we've had a significant increase in what we refer to as chaos, disruption, and certainly uncertainty. Part of the deal with Trump is that it threatens obviously trade, it threatens margins, and strengthens resiliency and sustainability. And obviously the chaos that's caused is a direct result of the fact that he's issuing executive orders and not giving enough sufficient time for companies to respond. Appreciate the fact that Trump's goals are pretty meritorious on the face value of it. He's looking to lower duty rates on U.S. exports around the world, and he wants more foreign investment and foreign purchasing done here in the United States. In fact, if you believe the statistics that the Department of Commerce is putting out, there are now over 100 countries around the world that have lowered their duty rates on U.S. Exports. And we handle a number of companies that do exporting, and a lot of these companies, their export businesses are uptick now in the last 60 days. The other thing is that the Department of Commerce is measuring the amount of additional investment here in the United States, companies that are producing and putting together manufacturing locations, distribution centers. There's more than $1 trillion of investment since February of this year. So while we have all this chaos and disruption, there's also a positive side to it. that some of these efforts will work. So it threatens resilience. It threatens sustainability in companies. And that's a lot of things what Citrin works on and has already brought your attention. But part of the issue is how do we deal with that? Well, first of all, we have to be able to pivot quickly. We have to be able to ascertain what solutions and what options are out there, which means that we have to develop resources. And Citrin is a resource for you because they come to us specifically about guidelines for tariff mitigation. And you also have to be creative in your approach. So over the last 30 years, we've developed 20 solutions. We're actually working on a 21st solution, which we're beta testing now. And because of the time frame, I don't have all the time in the world to go through these, but I'm going to pick a few of these and walk you through some case studies. How we go into the methodology of finding a solution is that we take 5 pillars of what we refer to as landed cost. So when we buy something from overseas as an import transaction, we pillarize 5 areas. The first is the acquisition of cost of the merchandise. Second is the freight. Third is the customs clearance. Fourth is duties and taxes. And last is the inlet, final mile, distribution, delivery to get it to point of value. We then have 4 steps. We look at a very detailed level, very granular, an assessment of how the supply chain works for your import or export supply chain. We create recommendations and we make sure that we apply a financial model to those recommendations to make sure there's an ROI on any recommendation that's made. Lastly, the third step is we create an operational model which answers the question, what do I have to do differently to make this recommendation work? And lastly is implementation, which generally is working with various government agencies to make the program successful. So one of the options that we have is what we refer to as bonded warehouses at foreign trade zones. And we use this solution very heavily all across the United States. We're actually operating now in 22 states all around the country. A bonded warehouse at a foreign trade zone is a physical location in the United States. It could be a manufacturing or a distribution location. But that location sits outside the U.S. economy once it gets that designation as bonded or FTZ. And that means that when goods cross through the border into that foreign trade zone bonded warehouse, there's no obligation to do a customs clearance and therefore no obligation to pay duties and taxes. So the first benefit that we get in that program is the deferral of the duty obligation to a later point in time. In bonded warehouses, we're not allowed to materially change the product. If it comes in a widget, it has to go out as a widget, so it's primarily designed for distribution. Okay, we have 5 years to move the goods through the facility. If anything that's exported from the bonded warehouse, there's no obligation at all to pay duties because the goods would never have entered the United States. In a foreign trade zone, we are allowed to do manipulation, manufacturing, and assembly. We have an unlimited amount of time to keep it in the FTZ. And it works the same way, which is if the goods get exported, there's no obligation to pay duties and taxes. But both of these things provide immediate relief on goods coming into the United States and deferring that duty obligation generally to the point of sale or point of value in your supply chain. Another option is for sale, and this has a lot to do with companies that buy from China, because we did an analysis several years ago and determined that about 70% of all the purchasing done in China is actually made through intermediary companies, buying agents or selling agents. And when they get used representing the factory, they generally take a fee or a commission in that relationship. And you end up declaring as part of your FOB value to customs, you're including that fee as the amount that's being declared to customs. Customs in the first sale rule says if you can legitimately identify that you're paying in your cost of goods purchased, that commission or that fee, you can extract that amount and declare to customs the value actually paid to the factory. So we have many instances in which companies are paying as much as 15, 20, 25% commission to a buying agent, and therefore they can lower their duty obligation by that percentage. Tariff engineering is something that's really taking hold in our business profile with lots of companies. which is basically the legitimacy of altering how a product is manufactured in order to gain advantage by changing the HTS number, and therefore lowering the duty obligation. As many companies know, executives know, Trump is going after products that contain steel, aluminum, and copper. Okay, and he's added on additional tariffs on either those things coming in as raw materials or those things coming in as part of the industrial product. So our engineers have been successful in changing some of the materials used away from steel and the copper to various other alloys or composites. Okay, and as soon as you do that, you dramatically change your tax obligation when the goods come through the border. There are lots of examples of this over the years, because it goes back as much as 35 years in customs regulations. Demand planning and trade review. Basic concept here is that when we usually import into the United States or export from the United States, we generally ship it by air or ocean. This is going to Canada and Mexico where trucks and rail is used. The rest of the world is either air or ocean. But air freight is 18 times more expensive than ocean freight when you look at it as a per kilo or per cubic meter basis, right? So when we look at a company's profile and see getting the payables right on their freight, and if they're paying more than 5 or 6% of their overall spend in air freight, you look at that, and generally what we find is that there's a failure in the demand planning system that's requiring them to ship goods on an expedited basis. So our focus then becomes improving the demand planning process so that they can time and use ocean freight, and therefore reduce that vertical freight in their profile. Alternative near sourcing obviously is a big thing. And you all know that President Trump, one of his goals is to try to bring back particularly critical manufacturing back to the United States. So we break this down to friendshoring, which is moving to a country that we have a more friendly relationship with. And a perfect example would be China, where we have manufacturing heavily involved, maybe moving it to South Korea, Taiwan, Vietnam, Malaysia, where we have friendly relationships and now have trade agreements in place that lower the duty, particularly as compared to China. Nearshoring is bringing it physically closer to the United States, so that could be used in Canada or Mexico or the Caribbean as an example, okay? And reshoring is bringing the manufacturing back to the United States. And many of the larger companies in the United States are using all three of these options in diversifying their sourcing portfolio. As we came through the 1990s and the early 2000s, there used to be a theory in purchasing and sourcing, and if you put all your eggs in one basket, you can negotiate your best deal. The problem with that concept is it works well in terms of negotiating your best deal, but creates a risk because if you lose access, that supplier has additional costs involved, such as if it was located in China, okay, then you're going to find yourself in a much more expensive supply chain. As compared to companies diversifying their sourcing portfolio, reducing their dependency on China, and moving it to various countries around the world, they create a risk management strategy in the supply chain that has a lot of benefit to it. As was discussed by the first two speakers in this session, there's a whole effort on the part of U.S. Customs to change its dynamic from being a trade facilitation organization to being an enforcement agency of the Department of Treasury. Okay, that's a huge cultural shift. And in our practice, which we handle about 50 to 60% proactively keeping companies out of trouble, the other percentage is when companies get in trouble, they come to us. We see an uptick now, the last 6 months, almost as much as 30% of companies having inquiries or particular problems related to customs. And one of the things that was brought up earlier was you can raise, obviously, potentially your exposure both on a business basis and a personal basis. And the key words is if customs determines that the act that was done was willful, intentional, or there was personal gain in the process, where they come after the companies much more aggressively. And you go from potentially just a civil case to one that's a criminal case, or one that just moves from the company to the executives that were involved in the transaction. So this is a very important area that companies really need to pay attention to, both on the import and export side. And very specifically on the import side, Customs is looking at the valuation, particularly with related parties. They're looking at the origin. They're concerned about companies transshipping the goods to another country and then claiming that that other country is the origin. They're concerned about the classifications, okay, the HTS numbers. And the last issue, which is even more concerning to us as a consultant in this line of work, is their request now for bills of materials. An example would be that if BMW made a car in Germany that they're shipping to the United States, they might import in Germany the leather from Brazil, the engines from Italy, the tires from France, electronic components from China. But we always had a rule of substantial transformation here in the United States, which means that if the car became a car in Germany, irrespective of where the materials were sourced from, we could say that the company, that car was made in Germany when it enters the United States. Whatever the duty rate is for a car entering the United States from Germany, that's what would be applicable. But Customs has changed this now, obviously, and they're asking now for bills of materials. And bills of materials, they're asking for a line item of all the materials that make up a specific product, okay, and what the percentage of that product is against the total. They're obviously looking for steel, aluminum, and copper, and there are higher assessments for that portion. But they also are asking questions not only of the value of that steel, aluminum, bill of materials, but the origin. And they're specifically targeting goods that are coming out of Vietnam and Mexico, where the Chinese manufacturers have moved their own plants to Vietnam or Mexico using 100% of Chinese raw materials and components. And Customs is now taking the position that if you can't evidence through the bill of material that there's a predominance of value add in Vietnam or in Mexico, then you can't declare it as made in Vietnam or Mexico. We have a number of our cases in our practice, and a number of the industry associations that we belong to have also seen an uptick in this whole area. So it's something to be very careful about and be very diligent about it. Remember those terms. You have to have a program that's exercising due diligence, reasonable care, and supervision and control. And that's best evidenced by having standard operating procedures, protocols, and training of the people in import and export regulations. So we have lots of options that are that are available to us. So it's not all a dismal circumstance. It's a matter of understanding what options might work best for us. And you can come back through Citrin to us to get a review of your supply chain, see which of those options might work. We almost have 100% success ratio of finding some solutions that will lower your landed costs when the goods come in. The culture comes from the top. This has to be a senior management issue, clearly, that tells us, that we need to make changes. It was brought up before, but that actually has to be part of the procedure, that there's a memo from the CEO and senior vice president and COO that says compliance is going to be an important aspect of our import and export program. Now we need to really think about risk management, okay, taking steps that lower our risk in the supply chain, not just lower cost. The 20 solutions that I mentioned, which ones are applicable to you? And theoretically, we always make the point of dealing with our clients is to stop chasing cost and really negotiate to obtain the best value for you to spend, because that's a risk management concept. And at the end of the day, it's a longer term strategy that I say I agree of success. So with that, I'll open it up to any questions that the audience has or any thoughts that they want to ask.
Yeah, thank you, Tom. Appreciate the update, and a pleasure hearing the mitigating strategies that you have. We worked on a few together, and some of the questions that come up when we work together on a couple of these is, you talked briefly about the foreign trade zones. So one question that we kind of have to address is, can any facility be classified as a foreign trade zone, such as a company's current warehouse? And how long does it take to establish a foreign trade zone?
So foreign trade zones are allowed anywhere in the United States, and they can be owned or third-party operated. It just obviously creates benefit to a company that's involved with importing and exporting. While there are national guidelines for foreign trade zones, every part of the United States has different nuances and rules that change it a little bit of what can be done. And that's one of the things we do is help companies navigate through those nuances that are done on a local basis. We used to say that we could get a foreign trade zone done in about 90 days, 60 to 90 days. But the government has put a slowdown, not only from the furloughs that had occurred, but just as a general statement since Trump has taken office. So we try to allow now for about 120 days, maybe even as much as 150 days. It has to be left to be able to get to an FTC. And remember that there's two types of FTCs. There's ones that do just distribution only, and those that do manufacturing and assembly. The distribution ones happen much more easily and quicker. The ones that include manufacturing, it takes a little bit more time.
Okay. Thank you for clarifying. One of the other questions that came through, again, the question option is open, should be for all of our attendees. What are the most common mistakes made that can trigger a red flag with customs and borders?
Any one of those areas that I highlighted earlier, it's the first one is the use of the harmonized tariff number, which has to be declared to customs at the time the goods come into the United States, that they're not using the right HTS number. We've been doing harmonized tariff line reviews for companies for about 35 years now, and we all come up ourselves. We average that when we go into any company, whether they're a Fortune 500 company or a top operator, that most numbers come around 30 to 35% of their HTS numbers they're using are incorrect. In some cases, by correcting it, it might increase the duty. And in other cases, by correcting it, it might lower the duty rate. So it's something that you have a responsibility for is that HTS number. The next is the valuation used, and particularly for related parties, that companies arbitrarily pick a valuation, but appreciate that there are very strict timelines by customs on how things need to be valued. At the end of the day, it's generally the transaction value, the price to be paid between the parties, that is representative of a wholesale market condition. And the last that there seems to be is the other problem is the record retention. That was one of the points that your colleagues mentioned, is that in the import and export world, the government agencies require that you have to have records of your import-export transaction from the communications that took place with the foreign buyer or supplier, all the way through commercial invoices, packing lists, bills of lading, quality control documents. You have to keep that for at least 5 years. So a lot of companies haven't been as attentive as they need to. And so when customs comes in and make an inquiry and they ask you for copies of documents and you're not able to produce them, that becomes a problem all itself. And lastly, is this bill of materials issue, is you have to start training your suppliers overseas that besides a commercial invoice and a packing list, that they're going to need to provide a bill of materials, which lists what materials go into those products, okay, and what the percentage of that particular product is against the total value, and the origin of that product if it's not from the country that you're buying from. A perfect example is we worked with a Italian medical products company, and they have all kinds of metals in their machinery. And when we asked for a bill of materials, they weren't able to identify where the steel came from. And in this particular case, the steel came from a country, Russia, which actually is prohibited, that we're not able to buy anything that's Russian. So they had to change their sourcing to a different country, which obviously then changed their pricing model. So it becomes very important, and we have to start training our suppliers all around the world that a bill of materials is already starting to come in. That will be a regular document used down the road.
Okay. One other thing you
Great point, Tom. I just wanted to quickly amplify, the point that you made about related party transactions. This is a topic that we're hearing from our current clients that we've seen in, some of the recent enforcement actions, where effectively, they'll take a look at, we'll call it a parent company importer, and to the extent that a related party is engaging in, a transaction with an import export. Related party transaction, you can effectively have, the ability to, manipulate the valuation and in turn underpay duties and taxes. So, not necessarily a widely publicized area, but certainly related party transactions are a key item to be on the lookout for.
I want to add to that conversation, which is that everybody obviously is conscious of how important AI is becoming in all aspects of business, but appreciate the fact that U.S. Customs now is integrating AI into its enforcement program. So the example I would give you, which is a real case study, is we had a client that was based in Maryland that had been importing products from China for the last 15 years. The company in China had a subsidiary in Australia, and they offered to the U.S. company that we could move the freight to Australia and then ship it from Australia to you, and you could declare it as Australian, which obviously carry a much lower duty rate than the goods coming from China. So in this particular case, Customs used AI, which is that the AI looks at data so quickly that when they brought in their second or third shipment from Australia, it raised a red flag for this customer because the AI said, hey, this company has been buying the same product from China for the last 15 years, and now all of a sudden that same product is coming from Australia. Customs offices in Baltimore, you need to take a look at this transaction, which they did. Customs showed up in the next import coming in. They pulled the shipment over for inspection. They opened the boxes, and they clearly saw that the goods were not from Australia, that there was this made in China. And now this company is being pursued by the customs authorities. And what we're trying very hard to do is to prevent it from being elevated to a criminal investigation, because emails were discovered in the discovery process that clearly showed that this was a blatant and intentional act, right? So to remain still be seen how this is being handled. But I just want you to realize AI was used by Customs to flag this particular shipment. And they're using it just like every other company is using AI to their advantage. So you have to be very careful because they're using tools now that makes it state of the art.
Okay, thank you. Thanks, Tom. One other question I think, Kevin, you and Atul, there's a question out there whether or not we could assist, or if we know those that could help assist in violation issues concerning other countries, such as Canada, Mexico, the UK, the EU, Asia. So.
Yeah, I guess maybe a little bit more context. I guess for the individual asking the question, certainly the clients that we work with, I mean, they've got imports and exports with globally, around the world. So I don't know if it's a question with dealing with Canadian regulators, Mexican regulators, other regulators, but certainly we're primarily U.S. based, so we are working primarily with U.S. importers. So I don't know if it's a question of, we don't have necessarily boots on the ground in foreign countries. But yes, I mean, we can assist with imports and exports issues, obviously with other countries, but primarily the focus is on U.S. regulators, including CBP and DOJ. So I think maybe to answer the question is maybe, but we could probably take that conversation offline. Happy to get clarification on that.
If not, I'm sure we could make some connections.
And John, we have an agency structure in over 100 countries around the world where we have resources in 100 different countries, which are the main ones that the United States trades with. So we're able to access brokerage services in those countries, attorney services in those countries, and various other professional services through that agency network. So somebody had a question or an issue, we can provide a resource to them.
Okay. Thank you. I think I'm just going to check our Q&A. I think we have time for one last question. So, how difficult, Tom, is, we talk about tariff engineering, right, as a solution. How difficult is that process?
We have engineers on our team to help support that asset specifically for the purpose that it is a difficult issue. The key issue is creating a paper trail or an audit trail to how you have changed the product by altering its materials or its makeup. That changes then its HTS number and therefore creating a lower duty rate. So sometimes it's a very simple thing. We work with a number of example food companies, and if they just alter what some of the ingredients are, which sometimes they have a lot of options to do that, that can change how the product's HTS number applies. So it could be a very, very simple issue. And then we have industrial products, which we're dealing with now, that have steel, aluminum, and copper in it. In many cases, they're using steel and aluminum, copper because those materials have particular properties that are needed for that piece of equipment. But the engineering team, in concert with the R&D team and the technical team at our client and also at the supplier, there are many times we can provide alternatives in that regard. So it's a very studious process. It's extremely detailed. Again, why we use engineers to do the actual work. But once you get it done, you create the paper trail and audit. So you can move forward with the benefit of getting change. You just have to be able to be prepared that if customs challenges you, that you can provide the backup proactively or reactively when questioned about it. That becomes part of the task. It's not just getting there, but being able to create that paper trail that shows how it was done so that customs can look at it and say, okay, it falls within the guidelines. I appreciate that customs employs what they call commodity specialists, most of them are based in Washington, who are experts themselves and engineers and have different skill sets in a number of different major product lines of goods that get imported to the United States. So they have an internal resource that they can turn to help evaluate bills of materials and processes to make sure that they're legitimate and valid.
Okay, check the Q&A box. It looks like we have no further questions for today's presentation. I want to, on behalf of me and the team here, I want to thank everybody for joining today. A copy of today's webinar will be circulated to those in attendance. But again, to Tom Cook from Blue Tiger International, Kevin Tanaka, and Atul Chandra here from Citrin, just want to say thank you to everybody for attending today, and have a great rest of your day.